Michael 1L rep with American Constitutional Society, and along with the Federalist Society, we're hosting this debate on the Voting Rights Act today. We have two speakers. They're going to have a few minutes to make remarks, then we're going to have a short rebuttal, and then we're going to open up to questions. If you do have class at 12:55, we'll leave a few minutes for you to get to class. And I'll introduce Professor Luis Fuentes-Rohr. He is a professor here at our law school and a here at TI's faculty fellow. Professor Fuentes-Rohr's scholarship focuses on the intersection of race and democratic theory as reflected in the law and democracy of the Voting Rights Act in particular. And his most recent work focuses on the political and constitutional status of the Commonwealth of Puerto Rico under American rule. He recently wrote a New York Times article called "Is the Voting Rights Act Still Needed?" So he'll be our first speaker. I'll introduce Michael here from the Federalist Society to give us our biography.
Afternoon, everyone. My name is Michael Nassif. For those who don't know me, I'm president of the Federalist Society Chapter here at Maurer. And it's great to see you all here, but like she said, we have plenty of extra pizza. I think you probably each have your own individual, so feel free to go grab more throughout this debate. Appreciate you coming out today. Our second speaker representing the Federalist Society today is Mr. Hans von Spakovsky, currently at the Heritage Foundation. He's a 1981 grad of MIT, and then he followed that up at 1984 with a degree in law from Vanderbilt University School of Law. Before joining Heritage in 2008, Mr. von Spakovsky worked at the Justice Department as counsel to the Assistant Attorney General for Civil Rights, providing expertise in enforcing the Voting Rights Act and the Help America Vote Act of 2002. After that, Mr. von Spakovsky served 2 years as a member of the Federal Election Commission, the authority charged with enforcing campaign finance laws for congressional and presidential elections, including public funding. Among other current responsibilities at the Heritage Foundation, von Spakovsky researches and writes about aspects of election law, such as campaign finance, voter fraud, and voter identification, as well as registration and equipment issues. He concentrates as well on civil rights, immigration enforcement, and government reform. He's co-author with John Fund of a new book, Who's Counting? How Fraudsters and Bureaucrats Put Your Vote at Risk. And he's also been featured many times in Politico, the Washington Times, the Wall Street Journal, and his series for PJ Media, quote, Every Single One, was nominated for a Pulitzer Prize. He also appears regularly on Fox News Channel and other national and regional TV and radio news outlets. Without further ado then, I'll turn it over to them.
So, you want Professor, who's going to go first? We'll let you guys start. Okay. All right. All right, we decided we flipped a coin and I would go first. And by the way, we are old debate partners. We were just comparing notes, and I think it's the third time back, so rematch.
Oh, actually, that's not quite true. Right. We've done this 3 times. The first 2 times, it was a conversation. Then I realized, I was told, I didn't realize this, that if we do a debate, that the Federalist Society pays for the pizza. So we're calling it a debate so that you get free food. Yes, you are welcome.
But I do want to thank the Federalist Society and the ACS, who, while they may disagree on issues, the great thing about those 2 organizations is that they put together functions like this where you learn what lawyers are supposed to do, which is to have a civil debate about substantive issues. I did also want to tell you, and I think probably half the people in this room will be interested in this, if you're interested in an internship in Washington, you should check out the Heritage website where I work. They have something called the Young Leaders Program. It's a great internship. It has 2 things that you don't often get with internships in Washington. First of all, we actually pay you. And second, we actually provide housing for interns, which is a big expense in Washington. So if you're interested in this, check out the website. It's not just in the summers. It's there's 4 programs: summer, winter, spring, and fall. I was actually at the Supreme Court yesterday, and I managed to get in, although there was such a big line for the lawyers. I haven't seen a line like that since the healthcare case, that I didn't actually make it into the courtroom. I made it into the lawyers' lounge. And for those of you who have not been to the Supreme Court, they actually have a overflow room for the lawyers. It's very nice. It's got couches and padded chairs, although yesterday it was so crowded with people that you could barely move. And what they do there is they have speakers up on the walls, no video, so you can actually hear the audio being piped in from the courtroom. I was actually there taking notes because I was writing an article about it, and when you do that, you have to be somebody who actually can recognize the different voices of the justices. So that's a little bit of the experience there. Let me tell you what was not at issue in the Shelby County versus Holder case. What is not at issue is the right of any American to vote, particularly black Americans. What was not at issue was taking us back to 1965 or Jim Crow, although you wouldn't know that if you read some of the newspaper accounts of that. When the Voting Rights Act was passed in 1965, the main provision that was in it to enforce the 15th Amendment was Section 2. Section 2 bans racial discrimination in the voting context. It applies nationwide, and it is permanent. Now, at the time, because of the fact that there was systematic, official, widespread discrimination, particularly in the southern states, Congress came up with another provision, Section 5. And it's Section 5 that was at issue in the Shelby County case that was argued yesterday. Now, if you go back and you look at the congressional discussions of Section 5, what you find is that it was supposed to be an emergency, temporary provision. In fact, it originally was only supposed to last 5 years. Now, what was the reason for it? Well, Congress was afraid, and they had good reason to be, that if the Justice Department, for example, won a Section 2 lawsuit and got a remedy to get rid of a particular law or practice in a particular jurisdiction, those jurisdictions would then immediately come up with a new rule, a new ordinance to be able to keep discriminating. And in order to stop that from happening, they put in this provision that said that if you are a covered jurisdiction, then you cannot make any change in your voting laws or practices without getting the pre-approval of the federal government, either by administratively submitting it to the Attorney General of the United States and getting pre-clearance, or by going to a 3-judge court, not anywhere in a federal court, but only in the District of Columbia. The Supreme Court, when it upheld Section 5 in 1966 in a case called Katzenbach, recognized that this was an extraordinary intrusion into state sovereignty unprecedented in American history, and that it was basically really at the outer limits of the power of Congress, but that the unique and frankly dire circumstances then existing in many areas of the South made it constitutional. Now, the way Congress set out that you would be a covered jurisdiction was based on the symptom of the discrimination that was going on. If you went to places like Alabama and Mississippi, you found that because of the official barriers to registration and turnout, blacks turned out and registered at rates so low in comparison to whites that it was, as the court said, more than a 50% differential in most places. So, for example, you would go to Mississippi and the registration rates of black voters there might be 15%, whereas the registration rate and turnout of white voters would be in the 60th percentile. So the triggering formula that was set out in 1965 was whether you had had a test or device on the books, some barrier to registering or voting, like a literary test, and you had less than 50% registration or turnout in the 1964 presidential election. Now, when they renewed Section 5 in 1970, they added the 1968 presidential election. And then when they renewed it again, they added the 1972 election. So the jurisdictions that are covered today, it's 9 states in whole, parts of 7 other states, but some of them, you would expect. Georgia's covered, Mississippi's covered, Alabama's covered. You probably aren't aware that 3 of the 5 boroughs of New York are covered. Arizona's covered, Alaska's covered. Some very unusual places that you would not expect. But the point is that the areas that are covered today are still covered based on registration and turnout in the 1964, 1968, and 1972 elections. When Congress renewed this law in 2006 for another 25 years, they did not update the triggering formula. Why didn't they do that? Well, because if they had updated the triggering formula to take into account current conditions, say the registration and turnout in the 2004 election right before they renewed it, none of the current states that are covered would be covered. Why is that? Because the barriers to registration and turnout have disappeared in those states. And in fact, this was something that kind of embarrassed the government yesterday. Why? Because the Chief Justice asked the Solicitor General, Donald Verrilli, he said, Mr. Solicitor General, can you tell me which state in the United States has the worst disparity between black and white voter registration and turnout? Surprisingly,
Don't tell him. Do you know?
Does anybody know? Well, you're just like the Solicitor General because he didn't know, which I found astonishing. Listen, we may have different views about this, but both of us will tell you that for the Solicitor General of the United States to not know the answers to those kind of factual questions was frankly an embarrassment. I mean, he should have been briefed on that. I was amazed. He didn't know the answer. The answer the Chief Justice gave him was the state of Massachusetts, which is not covered under Section 5. So then the Chief Justice followed it up by asking, well, what is the best state in the country in terms of there not being a disparity between black and white voter registration and turnout? The answer is Mississippi, one of the covered states. And that points out the problem with Section 5 today, which is that there simply is no evidence that the dire and unique circumstances that existed in 1965 that justified its constitutionality still exist today. In fact, look, one of the main reasons, as I said again, that Section 5 was put in place was because Congress was concerned about evasion of court decrees. There is no evidence in the record. There was no evidence produced to Congress when they were renewing it that any of the states that had had, for example, court orders against them under Section 2 of the Voting Rights Act, that they are today engaged in the evasion of court decrees. And of course, one of the reasons for that, as was pointed out by the dissenting judge in the Court of Appeals decision, is that if you want to look at the states that have the largest number and highest proportion of black elected officials in the country relative to population, the top 5 are states covered under Section 5. 8 of the 10 states with the most black elected officials are covered states. What are the worst states in the country in terms of not having black elected officials? 4 states that are not covered under Section 5, including Illinois, the president's own home state, Missouri, Delaware, the vice president's home state, and Michigan. And that, in fact, shows the success of Section 5. Because in 1965, there were virtually no black elected officials anywhere in the South, and that's one of the reasons you had the kind of persistent and widespread discrimination. That's not the case today. Blacks are elected throughout the covered states at much better rates than other parts of the country. And in fact, black voters register and turn out at higher rates in the covered states than in the non-covered states. So you simply cannot make the argument that Section 5 is still needed today because those conditions that justified it are not there. Now, another question that embarrassed the government, because remember, the government is saying there's still widespread discrimination, therefore Section 5 is needed. As the Chief Justice said to the Solicitor General, well, what happened in 2005, the year before Section 5 was renewed? How many submissions were there to the Department of Justice? Now, what he was asking by that is the vast majority of covered jurisdictions, remember there are 12,000 covered jurisdictions. If you include the states, the counties, the cities, towns, school boards, utility districts, there are 12,000 covered jurisdictions. Most of them submit any changes in their voting rules to the Justice Department for administrative preclearance. In 2005, the Justice Department received 3,700 submissions. The Chief Justice said, well, how many objections were there? There was one objection. Okay. One objection. That's not exactly a record of persistent and widespread discrimination. Now, Justice Sotomayor kind of led off the questioning yesterday. She immediately started interrogating the lawyer for Burt Rhine, and she made some comments claiming that, well, the Alabama record today is just as bad as it was in the past. That's, in essence, what she was saying. Well, in fact, in the last 12 years, the U.S. Department of Justice has objected to exactly one preclearance submission from the entire state of Alabama, from all of the counties, towns, cities, and the state. One. And it's been almost more than 20 years since the department objected to a statewide submission from the state. So the idea that there are large numbers of discriminatory practices going on is simply not true. Now, no one says, and Shelby County didn't claim yesterday, that discrimination doesn't still occur. But the point of that is that if discrimination occurs, you have a remedy. It's called Section 2. And not only as a private party can you do that, but the Justice Department files Section 2 lawsuits. In the last 10 years, the Justice Department has received literally tens of thousands of submissions. In that entire 10-year period, they've only had 37 objections, some of which, frankly, turned out to be wrong and were overruled. But the point is the government has plenty of resources to file Section 2 lawsuits if those objections are valid, to get a remedy that stops the discrimination. And there simply isn't a constitutional justification for Section 5 to continue. I'll end by telling you that when this law terminates in 2031, if it terminates, the states that will be covered in 2031 will be covered based on registration and turnout data that is what, almost 70 years old. That's as if in 1965, when they first passed Section 5, they said, well, we're going to determine coverage based on the registration and turnout in the 1896 presidential race between William McKinley and William Jennings Bryan, which would make absolutely no sense. Thanks.
I'm waiting for the...
No applause.
Maybe I should come. Well, good morning, and I'm going to grab the microphone for a second, though I was debating because I feel like Phil Donahue. Is that the name? I want to show you, I won't show you, I'll have you listen to a clip. There, I'm on the other side. Very brief, 45-second clip. Because let me just tell you, much of what I heard, I may or may not disagree with. However, to my mind, the debate is being played out in ways that are simply not the right ones. Here, let me just show you a clip and then I'll tell you. I don't think you know who it is, and it doesn't really matter.
You can let the screen down.
No, we don't need to see who it is. Here, listen. Here it goes.
Fact of the matter is that I think nobody can deny that a senator's, quote, philosophy, a justice's philosophy, a justice's personal predilections are always involved in the judgment that he makes. However pure a judicial restraintist you may think of yourself, there are certain elements of your background, history, and learning it cannot be disposed of simply by willing it that way.
If I had time, I would ask you if you knew who that was. I trust you don't. Well, that was Professor Philip Kurland of the Chicago Law School, Justice Frankfurter clerk, and I would say a very acerbic critic of the Warren Court. That was testimony given, can you hear that? Testimony given on day 10 of the Bork hearings. He was talking about the way judges decide cases. Well, I was thinking about that testimony when I was thinking about Shelby County. Here's the line I want you to think about. A justice's personal predilections are always involved in the judgment that he makes. However pure restraintist or judicial restraintist you may think of yourself, there are certain elements of your background, history and learning that cannot be disposed of simply by willing it that way. Now let me be clear, Professor Kurland is no judicial realist. He's no crit. If you want to see anything any more acerbic than what he's written, go take a look at the 1963 Harvard Law Review foreword written by Professor Kurland. I find it mildly persuasive personally. But the point is, he was no liberal. And he's telling us, right, this, you can't will away personal predilection. You cannot be a restraintist even if you want to be so. It's not so easy. Well, why do I think about Shelby County why did I think of him when I think about Shelby County? Well, here's why. Here's Justice Scalia, for example. This is yesterday's, if you read anything about the case today, this is yesterday's oral argument. The reference here was the fact that when the law was enacted in 1965, there were double-digit objections or dissents from the senators than voting. Yet the legislation, as it went on through the years, being, as the commissioner told you, has been approved now or reapproved in 1970, 75, 82, and then 2006. Every time that it came to the Congress, the senators' dissenting voices diminished, so that the last time in 2006, the vote in the Senate was 98-0. We could read that many different ways, which in fact, that's the way we need to think about Shelby County. How do we read and or understand the world? Here's how Justice Scalia read that set of facts. And I'm quoting here. I wish I was wanting to have you hear the argument, but we're not quite in the 21st century, so that they don't want us to see and hear what they're doing yet. But here's what he said. I think it is attributable, and I'm quoting, very likely attributable to a phenomenon that is called perpetuation of racial entitlement. And then you've seen, if you've read the case about the case today, it's made the news. In fairness, and I'm trying to be fair here, here's the rest of the quote. It's been written about, he said, whenever a society adopts racial entitlements, it is very difficult to get out of them through the normal political process. Like the Voting Rights Act, the reason we have it is because we just can't get rid of it. So now the senators are just lockstep, right? It went from 20 dissenters to 15 to 10 to 5 to none. That to me is the crux of the matter. To Justice Scalia ensuring a fair political process, whatever that means, right? To me, I'm sure we can disagree on what that actually means, but ensuring that or trying to ensure it free of racial discrimination is a, quote, racial entitlement. Now think about that and think about the Fisher case about to be decided. They might be the same piece, but that's a different panel. His argument, and I've been thinking about this, I'm trying to think about how does the court step in here? Well, here's the argument. It's a footnote 4 argument, which is, it just blows me away. It's an argument for a broken political process. Why does the court step in? Because Congress won't do it, says Justice Scalia. In fact, here's what it means. It means the blacks and the Latinos are running the asylum. That's what it means. Which kind of makes me feel kind of power to the people. That's right. So here's the thing, the future is grim if you ask Justice Scalia. That's the problem. Not to worry, however, because the conservative majority on the court is here to help. But that's the point. That's the only way I can read what's going on in Shelby County. Even when I agree with the commissioner, nothing he said, I would see him, well, maybe some things. Actually, that's not true. And we might get to that later. I don't have time for the moment.
It'll get you in big trouble if you agree with me 100%.
You know, that's actually a good point. I take that back. So here's two questions. This is Shelby County, boiled down to its bare essentials. One, whatever happened to judicial restraint? Where did it go? I'm looking for it and I can't find it. Now, don't get me wrong here. I am not suggesting I am of that ilk, though I do have to tell you, if you've been in my classes, you would know. And if you haven't, you're missing out. It's a party. Who is my favorite justice? You'd never guess. Well, Sotomayor is getting up there. Call it racial entitlement. She's very appealing. She's from the island, too. But she's second. Number one, well, actually, take that back. I'm not sure. I have to think about this. But my favorite justice, until I rethink it, is Justice Frankfurter. If you ask me about the reapportionment cases, I give you a different answer than most of my friends. If you ask me about Baker versus Carr, I'm trying to be consistent. That's all I ask. So when I look at Shelby County, I say, you know, we need an argument, which Scalia gave us, apparently. A broken political process. And I'm going to tell you about that more momentarily. Second question to think about. Whatever happened to originalism? Where did it go? Yesterday, I was very curious listening to the oral argument. That's what I want. I wanted Justice Scalia to fight the good fight. I wanted to hear him say, here's what the Reconstruction Congress intended by this 14th Amendment. I wanted to see it. Here's what the 15th Amendment meant to Bingham, to all those radical Reconstructionists, to Thaddeus Stevens. Name all the names from your AP courses or your Conlo 1 or wherever you've read. If you read your phone, or you know better than I do. We didn't get it. Hence the question to me, what's going on? What's happening? What is going on? What's behind Shelby County? I'm going to tell you what's going on. I have probably some minutes. Let me just answer those two questions and I'll tell you what I think is happening. So here's the question in Shelby County. Let's just start the question on the table. It's very simple. In fact, I call it disarmingly simple. What is the scope of congressional powers under the Reconstruction Amendments? Right? When you read Section 2 of the 15th, and it says, Congress shall have power to enforce the 15th Amendment, or this article, by appropriate legislation. The question for the court, and the only question should be, what does that mean? For Justice Thomas, the only question should be, here's how I read the history. I am no historian, he should tell you. He should concede that. And we know that's true. At least he should try. Here's how Foner tells me to interpret this. Instead, what we got was, this is a racial entitlement. Meaning, I don't like it. Which is kind of crass. I'm not all that keen on that argument, but that's me. So, one question we need to think about here. Maybe leave that aside. A question then to think about. What is a legal question? Well, what does appropriate mean? And who decides what that means? Right? What does Section 2 or the Section 2 power, what does it mean? Well, the legal standard has always been rationality. And once I say that, if you believe me, then you know the game should be over. Right? Are the ends pursued by the legislation legitimate? And the means and the ends, are they not narrowly connected, but connected in some rational way? Well, Congress, the court explained in the Katzenbach case of South Carolina, Congress may use, and I quote, any rational means to effectuate the constitutional prohibition of racial discrimination in voting. Well, how does Justice Thomas answer that question? How does Justice Scalia? Right? That's the issue. Well, here, let me give you an answer, and I'm running out of time, and I have a page and a half, so I'll be fast. Here's how Justice Scalia ought to answer the question. In fact, don't take it from me, because you don't have to believe me. I only work here. Take it from Ramesh Ponnuru, the editor of the National Review. Let me repeat. The editor of the National Review. Here's what he said. when it comes to the race cases before the court, the Supreme Court, too many conservatives abandon both originalism and judicial restraint. None of the justices, not even Justice, I'm quoting here, not even Justice Thomas, the most originalist member of the court, discussed any historical evidence about what the ratifiers of the 15th Amendment intended. It is hard to believe that back in 1870, they wished to empower courts. If you've read the history of the time, there is no way that's what it intended. There's simply no way. It's inconceivable. That's mine, not quoting. It is hard to believe, back in 1870, they wished to empower courts to determine which voting rights laws were necessary. The occasion for the amendment, after all, was the end of a civil war brought about in significant part by judicial overreaching in the Dred Scott case. I think he's right. In fact, that's my point. Where did originalism go? Where did judicial restraint go? So here, let me finish just to pick up on some of the things that the commissioner said, and then we'll open it up for question. Actually, we're going to take a few minutes maybe if we have time. Let's think about it a little bit differently, and I'm wrapping up here. It is undeniable the world's different today than 1965. There's no question about that. I can't sit here and tell you otherwise. Nobody could. Well, few people could, maybe. We've made significant progress, yes. Yet some of us think we're not there yet. Neither did the Congress in 2006. So the question is, who decides whether racial discrimination remains and how much, and whether the VRA, the Voting Rights Act, remains necessary? Should it be up to 5 politically insulated individuals with no particular expertise in political science, sociology, or social psychology? Should it be up to them? Let me close with this, and I'm wrapping. An opinion striking down the Voting Rights Act should only be understood and could only be understood as blatant judicial activism. I don't know how else you cut at it. Now, right or wrong, we can debate. Wrong. But there's no other way to explain it. It would not be based on the text of the Constitution. It would not be based on the legislative history of the Reconstruction Amendments. It would not be based on anything. It would be, to my mind, judicial will, plain and simple. So here's a silver lining, and I am wrapping up. In so doing, conservatives might find, here's a good thing about this. Maybe once and for all, they'll lose the moral high ground they think, or you might think they have, on the debate between judicial activism and judicial restraint. The fact will be clear to all that the emperor has no clothes. And that, to me, might not be a bad thing for the American public to find out. Thank you.
Well, I disagree with that because I think what you've heard, frankly, is an emotional argument, not a constitutionally based one.
I did get emotional.
And let me tell you why I say that. It's not judicial activism when the court restrains Congress from acting beyond its power. We are a government of limited powers. Okay? If you go through and you look at what Congress can do, you'll see that it's supposed to be a government of limited powers. And in fact, that is the purpose of the Supreme Court. If you look at the 15th Amendment, you'll notice it prohibits intentional. It's intentional discrimination. We didn't even get into this because this would take a whole longer discussion. Section 5 doesn't require intentional discrimination. It has an effects test in it. So you can be acting in a totally non-discriminatory, completely neutral manner. But you can still be found to have violated the law. Now, let me ask you all a question. How many of you think that Congress has the power to override the Bill of Rights and to pass a law that says that if the government decides that you have committed a crime, it does not have the burden of proof in prosecuting you. It does not have to show that you committed the crime. No, in fact, the burden of proof will be on you, the defendant, to prove you are innocent. How many people here think that Congress has the power to do that? Does anybody? Okay, well, that's exactly what Congress did with Section 5. It is a unique law, the only federal law I know of, in which the burden of proof is not on the federal government to show that a covered jurisdiction discriminated. No, the burden of proof is on Shelby County, on Alabama, on Kings County in New York, to prove that they did not discriminate. That is an extraordinary power that Congress has provided, and it's at the outer limits of constitutional power. And as the court said in '66, you can only justify that under dire circumstances, and those dire circumstances no longer exist. The other thing that puts it at the outer limits of congressional power is the fact that we are a federal system. You know, we are not France. In France, the provincial governments are simply divisions of the federal government. The state government in Indiana is an independent sovereign. And yet, again, Section 5 did something very unique. It gave the federal government power to basically veto any action taken by state legislatures or city council members in the covered jurisdictions. And again, you can only justify that under dire circumstances. And, you know, going back to data, the numbers that I give you are undisputed about the lack of objections, the huge number of cases, submissions made, and the very small number of objections made by the Justice Department. All of which, every one of which, the few that there are, can be remedied by litigation under Section 2 of the Voting Rights Act.
I'll be brief because I really want to get to your questions. Here's the issue. What is the constitutional test? And how do we figure out what that means? I mean, we can debate facts, or we can debate conditions on the ground. We can debate how much evidence is necessary. But in the end, really, the question should be, what does the Constitution mean? And the fact that we don't get from the court, in fact, when you read Fisher, and I trust, will read Fisher, look for this as well. You're not going to find it. What does the original meaning of the 14th Amendment is? That's just, to me, if the Federalist Society means anything, it means that. Right? That's Justice Thomas. That's Justice Scalia. Why don't we get that debate? Now, it's funny, right? I'm not here to suggest to you that's the debate we ought to be having. My point is, the court is doing something the court ought not be doing. And believe me when I tell you, you have to sit in my class, and if you haven't, that's your fault. I am being consistent here. When I tell you Reynolds versus Sims makes me uneasy, right? One person, one vote. I teach voting rights, and in that case, I'm not so crazy about. Harper versus Virginia Board of Elections, the poll tax case. When the cameras are not on, come ask me what I think about it. I will tell you. In fact, Max, could you turn off the cameras a second?
Set the timeout.
I'll edit it later if you want.
No, I don't trust you. The point is...
Yeah, you're going to edit it so that I say what he says.
I'm just looking for consistency. Right? So in the end, to say the court has to restrain Congress, and when it does that, it's not judicial activism. That doesn't quite work. You need more. You should ask for more. And we're not getting it from the court. In light of all the things that are happening in this case, the question becomes, we do have evidence. Now, is it the kind of evidence you want? Is it the kind of evidence that you think it's enough evidence? Well, of course, we can debate. That's a question of degree. Maybe it persuades me. Maybe it doesn't. It persuaded Congress. And we can debate, right? Is it a political process that happens to be broken? Maybe. But that's really a question for Congress, right? So what are we really doing? Here's 2 points. We're really fighting old battles. And I think of this time and place as the beginning of the end of the Second Reconstruction, if you want to think of it that way. Why? Right? Think about the way the court is now turning back on 1937. Right? These crazy judges doing crazy things, and the activism rampant, the Lochner Court, all of that stuff ended. Right? Why? Because we said, right, we are a democratic society. Let Congress do its work. If you don't like what Congress is doing, there's something you can do. If you don't like the Voting Rights Act, there's something you can do. If you think Scalia is just doing crazy things, there's nothing you can do. If you think the Roberts Court is just out to left field, actually, in this case, right field, there's nothing anybody can do, right? This is basic. This is Alexander Bickel. This is learned hand. This is not Louis, well, it is too Louis Fontesor, but I'm not quite there yet. I'm working on it. Right? This is basic constitutional history. And it's all gone away. Why? Because we have a revolution to fight. Make no mistake about that. Now, here's the thing, and I'll close here. In fact, this is also not just my point. John Noonan, he read this great book on federalism. He'll tell you, something's going on here. We're switching here. And why? And he's no liberal either, mind you. We're fighting a revolution through the courts. Now, is that good or bad? I'll leave that up to you to decide. But make no mistake, that's what is happening. And then the problem is, right, when we got the guys in the court, we fight when we don't, right? The Warren Court wasn't too liked by Philip Kurland. He attacked it. He criticized it, as he should have, right? No court is immune from that. I suggest the same thing is happening now. Let's make no mistake about that. This is the Warren Court Redux. It's just played out on different issues. Anyway, hopefully you have questions and we'll take them up. Thank you.
Let's take a second, just if you have to go to class. Thank you for coming. And there's also a sign-in sheet if you haven't gotten around to it too. I know it says ACS on the top, but it's for everybody. So then we'll let you go to questions.
You're welcome. That's really fun. Thank you. Thank you for doing this. I have a conference in Berkeley next week. It's overnight. I couldn't do it. I'm thinking of you doing all this travel. It's too much. Oh, don't you like to go? Yeah, Emily?
Well, I got 3.
I have 4. One in college, and I have a little guy in second grade.
This is an
This one, oh, because of Shelby County. Yeah, whenever.
We'll go ahead and take questions now.
Thank you.
Hi. Thank you for coming, first of all. I have a question for the second speaker. I'm sorry, what should I address you as?
Anything you want. Second speaker works. Go ahead.
Sir. So, I never heard you address the gentleman's point about Section 5 of the Act is redundant and perhaps lacks a purpose because grievances can be addressed under Section 2 of the Act. And I'm just curious if you have a response to the point.
I do. One thing I don't think is right, historically, is the point made that, in fact, let me find it's not a quote, about Section 2, where did I put it? Oh, back in 65, the argument was made that Section 2 was a primary tool by Congress. Section 5 was, I forget what you called it, an addendum, maybe. Can't remember.
temporary.
Well, it is that, but I thought you said that Section 2 was like a, well, it turns out Section 2 was not really all that much, it turns out. Historically, the way that it actually happened was Section 2 was a throw-in clause, basically codifying the 15th Amendment. Congress put it in there, heaven knows why. I couldn't tell you why. It was so mundane, in fact, that when Congress debated these issues, and Senator Irving is going after Section 5 for days and days and days, Section 2, when it came up, he left it, he didn't care. No, I mean, who could be against codifying the 15th Amendment? Of course, Section 2 took in a new light in the late 1970s. Why? Because of Washington versus Davis, which is, common law, right? The purpose test. Purpose is just hard. Unless you're trying to figure out the purpose of Congress in enacting laws, and you're on the other side, otherwise purpose is just hard. So then, litigators figure out, we need to find a different way to get around Washington versus Davis in voting rights cases. Let's come to Section 2. So, in the end, here's the problem with Section 2, the problem that we're going to have, and I'm not giving anybody ideas that they already don't know, this is in print. To my mind, Section 2 is the next step. Does it get us around Section 5? Probably not, right? Because the point of Section 5, this is a point being made by people, let's get rid of Section 5, Section 4, and let's do Section 2 nationwide. But the problem with Section Y, think of it's a restraint on things that, in fact, it came up yesterday. The government's lawyer really made this point in the argument, right? That there's some things like moving polling places, changing hours. Like you couldn't have Section 2 claims was the response he made, and we can, of course, debate this point. But his argument was Section 5 is applicable to things for which there's a need, he says, and I think that's a fair point. Section 2 is a very specific aspect of the law that takes time, and the whole reason we get around or away from litigation here historically was because these things took forever, they took time, they were expensive, and in the end the target was a moving target. So we needed Section 5 for a particular historical reason. Now we can debate whether that's still necessary, but really the question becomes who needs or who should be debating that? Should we be doing that here? Should Justice Scalia decide on his own? You know what, I read the tea leaves, I read the history here, I read the social science data. He doesn't, let's assume he does. I don't see it anymore. Which is why I didn't address the point, because to me that's not the right question. I mean, I can engage it, I disagree. I think Section 5 is needed, they disagree, here's my response, he disagrees. But in the end, who gets to decide that? I mean, that's the question. In the 60s, you know what the answer was? In fact, ask those who were around, the conservatives in the 1960s, what was the answer? Ask the Nixon Justice Department, what was the answer? It was Congress, until we get 5 votes on the court. And then it's not Congress anymore. That's why I didn't address the point.
Certainly it should be Congress, you're right, but I'll let someone else answer.
Okay.
Thank you.
Well, let me just say, because I thought this was actually amusing. Yeah, the Solicitor General yesterday said, as a professor, talked about that, well, Section 5 helps prevent discriminatory polling place changes. And they just couldn't do anything about that with Section 2. So you know what I did after the argument? I went and I checked the Justice Department website. Because, you know, they list all the objections they've made in the last 10 years. 10 years. With tens of thousands of submissions. You know how many polling place changes they've objected to in the entire covered area, 9 states, parts of 7 other states? 1. And that one is supposed to justify this statute. And when the government, by the way, said yesterday, oh, well, Section 2 just, you know, isn't a powerful enough tool because it takes too long and stuff, I can't remember which justice, one of the justices said, what, you've never heard of temporary restraining orders or permanent injunctions? Listen, I used to litigate and enforce Section 2. And if we saw a problem and we wanted it stopped right away to stop discrimination, we immediately went to court, and we're always very successful in getting restraining orders to stop the discriminatory treatment until there could be a full hearing on it.
But really, that's the point, right? You have Section 5. States know there's Section 5. So any changes must be submitted to the Justice Department. Imagine a world without Section 5. What would happen? Right? Then you say the day before the election, well, actually, by the way, we're moving it to Carmel, election to Monroe County, we're moving to Carmel, Indiana. Just kidding, we can't do that. But you get the drift. And we don't know what a world without Section 5 would look like. Now, do I trust Alabama? Apparently the Chief Justice does. And I say good for him. Trust whomever you want. But the question becomes, who gets to make that decision to say, you know, a world with Section 5 leads to one objection. To me, that's a good thing. The argument also can be, well, you know, that means that there's no danger anywhere. Maybe that. But one side is willing to take that chance, the other side is not. Especially, objections aren't really all that complicated. You know, I did this. Here's a fact. Go take a look. 60 days. Tell me what you think. No problem. It's not really all that costly anyway, right? So in the end, the question becomes, what are we really talking about? Right? What kind of world are we living in, and who gets to decide what world we live in moving forward? That's the question. To the majority on the court, it should be the conservative majority. I say, wow, what's happened? It is not your grandfather's conservative movement. But of course, we already knew that.
Thank you. Brock?
This is for Mr. Spakowski. Von Spakowski, sorry.
You get bonus points for pronouncing my name right.
Wait. Try mine. Go on.
Luis.
No, that's not my name. Go ahead.
Yeah.
So, if all these covered jurisdictions are, doing so well with their voting practices, why isn't the bailout provision enough? Why do we have to strike down Section 5 facially? Why can't we just let all these people bail out?
Well, because there's two answers to that. First of all, the fact that there's a bailout provision, and we didn't talk about that, but there's a provision in Section 5 that says that a covered jurisdiction can go to court if they meet a whole series of standards that are set out and requirements. Then judges can say that they're out from under the statute. The fact that you can get out from under an unconstitutional statute doesn't make the statute constitutional. That's the first thing. Again, go back to my earlier example. If Congress passed a law saying you would have the burden of proof to prove you're innocent if they prosecute you, but there's some way of getting out from under that, that exemption would not save the statute. The other problem is that the bailout is unrealistic. Remember what I said. In the last 12 years, Alabama has had one objection filed for one small town in the entire state out of the thousands of submissions they've made. That prevents the state of Alabama from bailing out. Why? Because they are considered under the law responsible for the actions or misactions of all the political subdivisions underneath them, even though the state legislature, for example, has absolutely no control over the city council in this one small town in Alabama. So they would not be able to bail out.
I have two questions, and first one might be very simple. Since I'm not a law student, I haven't been following the case, so maybe you could just clear this up a little bit for me. So what are the possible decisions? I'm a little unsure as to if just the constitutionality of Section 5 is under question, or Section 2, or could the whole law be thrown out? And does it need, can it be required that Congress makes a decision, or not necessarily? And my second question is regarding so we talked about the covered jurisdictions.
Right.
So I'm wondering about the areas of the country which are not covered jurisdictions, right? So supposedly Section 5 and or Section 2 give the federal government enforcement power in the covered jurisdictions. But what about, like, if, there's great disparity in Massachusetts, as you said, where's the enforcement, for that, and where does the authority come from?
Sure. Look, the professor and I have been talking about two parts of the Voting Rights Act today, Section 2 and Section 5, but there's a lot of other provisions in it. The only thing at issue in this case is Section 5, not the other provisions. Section 2 is not at issue because, as I said, it's permanent and it's nationwide. So if you had a problem in Massachusetts, and in fact, when I was at the Justice Department, there was a problem in Massachusetts, in Boston. And we used Section 2 to go after the city of Boston for discriminatory practices. Section 2 lawsuits can also be filed, of course, in Section 5 jurisdictions because the legal standards are different between the two laws. But I think was that both questions?
Oh, and what's at stake? Just Section 5 or Section 2?
It's just Section 5 now.
It's Section 4, the coverage formula he's been talking about.
Right.
And if you throw out Section 4, then nobody's covered. If nobody's covered, Section 5 goes away, right? Because there's no enforcement of Section 5.
So Section 5 is the covered jurisdiction.
That's Section 4 determines is the formula that the commissioner talked about. Section 5 tells you once you're covered, here's what follows.
Right, and it is possible that the court could come back and say, well, we're only throwing out Section 4 because the triggering formula is not congruent and proportional. You guys you probably have heard those words, because it's not based on current conditions. That would give Congress the ability to go back, and if they could come up with a triggering formula based on current conditions to possibly, reinstitute the law. But as I said, they would have a difficult time because the barriers to registration and turnout are gone, and that's certainly shown by the registration turnout rates of black voters.
Another thing they could do, incidentally, just to be fair to the court, they could do like in 2009 to the question about bailout and say, it's too onerous. If bailout is treated the way it reads, it's unconstitutional. So we, the court, will amend the statute. And they did. This is the Namudno case. And then at that point, they could just say, Shelby County, get out. I don't think they can because they have incidences of discrimination within the last 10 years. But maybe they come up with a new formula. The last year, the last 2 years, the last 3 years, who knows? And if Shelby County gets out, then the case goes away. I don't think they can do it this time. They did in Namudno. But this one, it's a much harder, the passive virtues will not arise so easily in this case.
Well, in fact, they can't because the Shelby County specifically said we're not seeking bailout, which was an issue in the earlier case, and in fact,
because they couldn't. I mean, to be fair, on the book they had a case of racial discrimination in redistricting within the county within the last 10 years. I mean, it happened. They went from a district of one black representative to 0. I mean, they retrogressed, and not to get too much into this, but they clearly violated the law on racial grounds.
Not the county. A town
within the county
over which the county government has no control.
Correct. Enforcement capability nationwide, do you think it's enough?
I'm sorry, can you say that again? I didn't hear.
Section 2, do you think it has enough enforcement capability nationwide? Section 2 lawsuits, as you said.
Well, the problem is timing, which is why we have Section 5 in the first place. Do you think if we get rid of Section 4 and Section 5, that jurisdictions will behave in ways that they ought to, right? They won't start, for example, creating, think of an election where you have police officers put roadblocks right outside black districts. And if you think in Florida 2000, you might be right. Can we trust jurisdictions to do what needs to be done? That's really the question. We have different views on that, clearly, which is really the point. Here's different views on a question. Well, we live in a republic and democratic government. Who should decide that? To me, that's the question.
Let's take another question, but I should say I was at the Justice Department, and we sent lawyers down to investigate that claim of roadblocks in Florida. It was not true.
We'll take one more question. All right. I got one for each. First for Luis. Given the over and under inclusive problems with the coverage formula, is there an argument to be made that the means is not rationally related to the ends?
That was asked and answered in '66. So the question becomes, what has changed from then? I mean, on the way you put the question, the question, of course it's over-inclusive, of course it's under-inclusive, but any line you draw will be that. Is it rationally so? Well, the states that are not in, the states that are not out, are you making that line in a rational way? The answer was yes. The question then, as you're asking it, has anything changed from then to now? That's really the question. Should we overturn Katzenbach? That's the question.
I mean, if the purpose of the legislation is to rid racial discrimination in voting, yet the effects, Massachusetts has the biggest discrepancy, but it's not being covered by the formula, while states that have, and this goes to another question I had. You mentioned a lot, the first speaker, about how because covered states have low, or they have high low, it seems that there's low discriminatory effects. Is that maybe because they are covered and not because they're inherently not discriminatory?
That's the argument. The argument being made to the court, but they don't seem all that persuaded by it. But that's exactly the argument. One argument is the first one, and the response is the second one. The question is, how do we pick between those two?
Well, what's important to this is that this whole argument that, all these places will go back to discriminating without if Section 5 is not there, I mean, that frankly brings up something that I think is very distasteful from an American judicial and justice standpoint, and that's the idea of, what do they call in Old England, taint of blood? None of the individuals who were in the government and were discriminating in 1965 are in government today. In fact, their sons and daughters are not in government today. We're down to the next generation, grandchildren, and in fact, many of the people that are in office today in the South, as I told you from the statistics, are the grandchildren of people who fought the civil rights battles in the South because they have so many black elected officials in these southern areas. But we're supposed to believe that the grandchildren of these people are going to commit the same kind of discrimination that occurred 50 years ago when the Section 5 was passed as a temporary provision for only 5 years.
Fair enough, but here's the answer. This bill was passed 98-0 in the Senate, which tells me there's a whole heck of a lot of Southern senators voting for this. Now, I don't know why.
Well, I can tell you.
Justice Scalia has a story.
I can tell you why.
But that's motive review, right? We're going to go behind what legislatures do and say, well, Congress, why did you do this? I mean, we could do it. We don't like doing it. But in the end, the argument is, if you don't like the Voting Rights Act, go elect different people. Vote those people out. Alabama, they let you down. They casted aspersions upon your name and your grandfathers and foreparents. And they're not doing that. Maybe they did. I don't know. I haven't followed Alabama politics. I'm not all that keen on it. Fact of the matter is, 98-0 is a lot of people. And still now we're saying, court, you know what, we're casting aspersions. Court, you avengers, you fix it. Second point, there's social science data here. The Valentino and Sears have a piece in the American Journal of Political Science. There's actually racial disparities in public opinion on grounds of race, believe it or not. South and North, there's actual data here. The two regions think about race differently. And one, I won't tell you which one, thinks about it in ways that we'd rather not think about. So the point is, right, we're not just, my point is, do we want to trust those pages that did really bad things 50 years ago? Are we ready to trust them? Well, the better question should be, who decides that question? 5 individuals in a democratic society that know no better than you or me put together? Or should it be up to Alabama senators saying, you know what, let's think about this. Should we continue this? To me, that's the point.
Under that point of view, Congress could pass laws overriding any of the provisions of the Bill of Rights that they don't like.
I guess they could do anything. They could also go to the moon, right? I mean, but what does that prove? That doesn't prove anything, right? Of course they could do it.
It proves that the purpose, one of the main responsibilities of the Supreme Court is to make sure that Congress stays within the limited powers it was given and does not become an all-powerful government.
But that's just cliche.
I mean, it is not a cliche.
But no, I agree. I hear you. I really do. But that's just, of course, nobody should. I mean, that's like civics, right? Nobody should go beyond constitutional power by the way we have a constitution so that we bind ourselves. But what does that really mean? In this case, right, it's a question of degree.
No,
right?
you're saying that if Congress votes to pass a bill,
Congress did.
If Congress votes to pass a bill, that should be the end of the story.
No,
and
that was the story in 1960.
That
was the story back when the Warren Court was around.
Whatever they agree to pass should be within the power of Congress to do.
So tell me what changed. Not only that, what changed in terms of the ways that the conservative movement has understood this question. I mean, this is not me. I'm not crazy. Well, maybe I am crazy, but I am not making this up. Justice Scalia is on record saying, originalism binds me. Why? Because I don't trust myself. Unless, wink, wink, it comes to racial entitlements. That's a different conversation. Then I'm all out. Because why? Give me a reading, right? Give me a story. Give me something about Bingham passing the 14th Amendment. I want to see it. He won't find it. He could try. He's not even trying. Nobody's trying. So the question is why? Why are we not trying? Because it's not there. So what are we doing? And I agree. Right? I agree with the story. The Constitution binds Congress. So what binds the court? I thought it was originalism. Unless, of course, it's not. And I love to continue this really interesting conversation, but I have to go to class.
Unfortunately, we're out of time. Thank you all very much.